start with the usual precatory information. This is a webinar that's open to a larger group of people. So this applies to the Q&A in particular. If you're going to ask a question about your own experiences, I would keep it fairly general, just because this is not confidential. So Bostock versus Clayton County was actually 3 cases that the Supreme Court heard together. 2 of them involved the firing of an employee for identifying as gay, and 1 involved firing an employee for identifying as transgender. The case involving the transgender employee actually originated from Michigan. It was originally decided in the 6th Circuit Court of Appeals, which covers Michigan, and that pertained to an employee of a funeral home who began the process of transitioning from presenting as male to presenting as female, and that prompted the employer to terminate their employment. And I'll be coming back to that issue of transitioning again later, because it's an important element of the impact of the decision. Now, the court considered the question, does Title VII of the Civil Rights Act prohibit terminating an employee because they're gay or because they're transgender? And the court answered yes. And how it got there was that Title VII, which I'm sure is familiar to many of you as the sort of general baseline law at the federal level for anti-discrimination, prohibits discrimination against employees on the basis of a number of categories, including race, national origin, and also because of sex. So traditionally, that had been understood to mean discriminating against an employee or harassing an employee on the basis of their biological sex. So a company that disfavors women and prefers men in terms of hiring and promotions, for example. Well, what the Supreme Court did in this decision was that they held that the concept of because of sex includes not only that traditional, very somewhat narrower understanding, but it also includes discrimination based on sexual orientation or gender identity, because you can't come to the conclusion that you're not going to hire a person based on their sexual orientation or gender identity without considering their biological sex. So an employer who is saying that they will not hire a gay man is partly making that determination based on the idea that they would only hire a man who is attracted to women, not a man who is attracted to other men. And that has to do with making a judgment about what they consider to be the acceptable behavior of biological males. Similarly, for a transgender employee, if the employer doesn't want to hire someone who's transgender because they're transgender, that's premised on the idea that the employer only wants to hire people who behave or express themselves in conformity with their biological sex and do not have a gender identity that differs from their biological sex. According to the Supreme Court in this decision, you can't disentangle those issues from biological sex, and therefore sexual orientation discrimination and transgender discrimination are sex discrimination. Now, the court took some pains here to emphasize what they were not going to decide in this opinion. The court said that they weren't going to address the issue of whether there would be disputes about use of facilities or bathrooms or locker rooms within workplaces or other public accommodations, because that issue wasn't before the court. So the court didn't give any real guidance one way or the other about how it would rule in a case where, say, there were restrictions on a transgender employee using the restroom of their gender identity, but not their biological sex, for example. The court also didn't really weigh in on how it would handle religious objections on the part of employers to hiring a gay person or a transgender person. Now, I think it bears emphasizing here that the religious defense for anti-discrimination law is exceptionally narrow, or at least has traditionally been exceptionally narrow. It really is only thought to cover employers who are themselves religious institutions, such as churches, that are making hiring decisions about things such as their ministers or lay employees who provide some religious function or religious instruction. So for most businesses, particularly those in areas such as manufacturing, logistics, the religious defense, I would be deeply skeptical of that being viable going forward. But the court was at pains to say we're not talking about that yet. So apart from saying that Title VII prohibits discrimination against LGBTQ employees, we should think that this is going to have a larger impact, because every time the word sex or sex discrimination is prohibited in another law, Bostock is going to be powerful evidence that that should be read to include LGBTQ protections as well. So that could trickle down to state laws. Obviously here in Michigan, we have the Elliott-Larsen Civil Rights Act, which in many substantive respects tracks Title VII and is usually interpreted alongside Title VII. Now, a fight has been playing out in Michigan concerning state law over the last several years as to whether the Elliott-Larsen Civil Rights Act prohibits anti-LGBTQ discrimination. At least one Michigan Court of Appeals case holds that Elliott-Larsen does not address that. But the Michigan Civil Rights Commission and the Department of Civil Rights has been taking enforcement action based on a different interpretation. They've held that you actually cannot discriminate against LGBTQ employees under Michigan's law. And it set up a series of battles over the last, two governor administrations here in Michigan, concerning who has the authority to make that interpretive choice. So we might see this. Bostock is really putting its thumb on the scale in favor of the MDCR's view that Michigan's law, because it also prohibits discrimination on the basis of sex, would protect LGBTQ employees. Time will tell on that one. This will also impact virtually any other regulation at the federal level that refers to sex. And so I would imagine we're going to see a series of tag-along cases that try to apply Bostock in other contexts involving things such as wage parity between men and women, in terms of eligibility for certain types of benefits from the government, including things like from the Social Security Administration, as well as in the benefits context with respect to private insurance and other plans, to the extent that there is a sex discrimination prohibition built into a particular law. Of particular interest to manufacturers who have collective bargaining agreements and have to deal with the union, the anti-discrimination clauses that sometimes are found in collective bargaining agreements often track the language of Title VII, which means that they create a grievable breach of the CBA if there is discrimination on the basis of sex or race or other protected characteristics. Well, after Bostock, we might look at those agreements anew, and the employees could argue that those CBA clauses also create grievance rights for LGBTQ employees who have been discriminated against or mistreated in the workplace. So this actually could spill over and have some interesting effects on the union versus management dynamic as well. Now, really what we're doing is we're taking a new concept and grafting it onto something that is going to be familiar to HR professionals and managers across manufacturing sector and other industries, which is many of the same principles that we already use to prevent discrimination in the workplace involving race or national origin are now, we're just going to carry those concepts over to LGBTQ discrimination. I don't like to presume a high level of familiarity with transgender issues when I'm talking with an audience that, where maybe some of these issues haven't come up in your particular workplace before. So I won't belabor the point, but I did wanted to touch on a couple of common terms that I'll be referring to, just so that people have a sense of what I mean. Generally, the definition of transgender is an individual who identifies as a gender different from their biological sex at birth. So someone who is born biologically male, but identifies as female and views themselves as female. This does not necessarily require a particular form of expression. Some people who are transgender have surgical interventions to bring their gender identity in line with their physical appearance, but that's not necessary to being transgender. There's a whole variety of expressions of gender identity. Cisgender is an individual whose gender identity aligns with their biological sex at birth, and that would be the majority of people. Transitioning is a catch-all term for the process by which a transgender person begins to have their outward appearance become more in line with their gender identity. And that includes dressing differently, perhaps hormone therapy, changing their name, the use of different pronouns, and or surgical procedures, among other methods. Many transgender people, when they're transitioning, that will involve a combination of these, but not necessarily all of them, or one to the exclusion of others. And finally, this didn't come up in the court's opinion, but there's a related concept, which is people who are non-binary or gender fluid. And this is something that's becoming a little bit more out in the public discussion over the last couple of years. And these are people who would not identify as transgender. They're really more an individual who does not identify necessarily as either male or female. They may request the use of neutral pronouns, such as they or other terms. And we would think of this as really the legal rules surrounding treatment of those individuals in the workplace should really be very similar to those for individuals who are transgender, but they're distinct concepts. So it's helpful to think of them as related but different. So what about workplace impacts? So Bostock is likely, I would suspect, to lead to a continued increase in the number of employees who will feel comfortable identifying themselves to their employers as transgender or non-binary. That would be very similar to the process that played out in the 90s and early 2000s, where you had a series of court opinions as part of a cultural shift towards greater openness surrounding sexual orientation. And so employees became gradually more comfortable being honest with their employers about what their sexual orientation is, or at least not actively trying to hide it, which would have been the norm in the 70s, 80s, and much of the 90s previously. So we would expect that there will probably be some additional openness about transgender status, and that Bostock's going to contribute to that in the workplace. Consistent with that, employers should look anew at their existing written policies on discrimination and harassment. Now, many employers were ahead of the curve and already prohibited discrimination on the basis of gender identity or sexual orientation before Bostock was decided, in which case, they might already have a good working policy in place. But if you don't, it should be revised to include these as protected categories and be very explicit that the company is not going to permit discrimination or harassment against individuals on those bases. You should also think about whether and to what extent you need to make adjustments to things like medical leave or other benefits so that they're available on an equal basis to both transgender and cisgender employees. So we don't want to treat a transgender individual's request for medical leave, say, for example, because it relates to hormone therapy or surgery. We don't want to treat that any differently than we would a request from a cisgender employee to need time off for another type of surgery, just make something up, knee surgery or, some other type of procedure. We want to make sure that we're treating like as like there. And because that's another potential area where you could see a discrimination claim arise. To the extent that you have anti-discrimination and anti-harassment training that you're doing with your workforce, that's going to need to be updated as well. We're going to want to explicitly address any type of harassment or discriminatory behavior that would be directed at gay or transgender employees. So this really also underscores how hostile work environment harassment is a much broader concept than what we traditionally think of, which is sexual harassment, where it's unwanted sexual advances from, say, a supervisor towards a subordinate employee. Really, it encompasses a much larger world of hostile conduct that can be racial in character, it can be national origin in character, and here it can be in the form of abusive conduct that's based in sexual orientation or gender identity. So what do we mean when we're talking about the kind of harassment we need to be newly aware of or focused on preventing after this decision? One thing to think about is that many of your supervisors might be savvy enough or well-trained enough not to engage in conduct that would be offensive to a transgender or gay employee. But Harassment by coworkers, I suspect, is going to be a particular recurring source of claims after this decision. Companies can be liable for coworker harassment if they're made aware of it and then they fail to do anything about it. So common forms of harassment here against gay employees, the use of slurs, which I need not repeat, using homosexuality as a shorthand for men being weak or passive, or for women being too masculine or aggressive. Now, some of those types of remarks were probably considered harassment even before this decision, but if there was any doubt about it before, it's gone. We can be confident that sort of attributing homosexuality as a negative and using it as referring to it as such would definitely contribute to a harassment claim. Similarly, teasing, pranks, or jokes about a person's sexual orientation should just be completely off limits. For transgender employees, there's been increasing news coverage of just the sheer amount of, in some cases, violent harassment that transgender people experience in our society. And some of that, unfortunately, does happen in the workplace. And so we need to be newly attentive to that. And that includes not only something that would never be acceptable, such as violent or threatening behavior, but there's also other things that are just more offensive or insulting that we should be watchful for. Deliberate misgendering. So even though a person's, because they're transgender, now identifies with a particular gender, insisting on referring to them based on their biological sex. So, a biologically male person has transitioned to presenting as female. We nonetheless insist on referring to them as he or him, even after we've been asked not to. If that keeps getting repeated and it's being done in an intimidating way or an insulting way, that's going to contribute to a harassment claim. Crude or insulting comments about appearance or anatomy, absolutely going to play into a harassment claim under this theory. And we should also be thoughtful about using policies such as dress codes or grooming standards in a way that unfairly singles out transgender employees, particularly those who are going through the process of transitioning, where their features may not align with our grooming standard, or their change in dress may not initially align with the dress code that was previously applicable to them. So there are really a few takeaways here. A lot of important top-line issues haven't changed at all. The best practices for preventing discrimination and harassment claims really remain much the same, whether we're talking about sexual orientation or whether we're talking about race or traditional biological sex. First and foremost, you want to emphasize a workplace culture of civility and mutual respect. The reality is that harassment claims often arise after a long period in which a lot of inappropriate behavior was being tolerated before it became overtly discriminatory. So if that behavior wasn't tolerated to begin with, chances are it would have never gotten to the point where someone was, say, repeatedly being called an offensive nickname or being subject to demeaning practical jokes or unwelcome sexual advances. That sort of behavior can be nipped in the bud early on. And that's really a key element in an effective anti-harassment policy is to create a workplace environment where there's just not an opportunity for that type of harassment to occur. We might also think about what operational changes may be necessary. So, for example, flexibility with respect to grooming or dress code policies for a transgender employee who's transitioning, allowing the employee to follow the standards for their identified gender rather than their biological sex. The Supreme Court's decision in Bostock did not require employers to make any type of special accommodations for gay or transgender employees, but we should be thoughtful about how otherwise neutral policies could be applied in a way that's going to discriminate against a transgender or gay employee. And as always, you want to encourage employees to report inappropriate behavior, offensive behavior to human resources or other designated personnel as soon as they happen so that you can intervene and address them. And so long as you're doing that and doing that effectively, that's your best and often a decisive defense against harassment claims. So it's both good for the bottom line in that it helps manage any potential claim and gives you a good defense to a harassment claim. And it also is just good for the workplace environment. It decreases the likelihood that you're going to have unhappy employees who are suffering under harassment and abuse. So that's sort of my overview of where I kind of think things are headed. I'm certainly interested to hear from Dave and others about questions.
Matt, thank you so much for that presentation, and I think there's a lot of very good information there. Let me open this up for anyone who might have questions about the case or about what Matt has had to present. I'll start things off. Matt, you kind of touched upon the idea that there doesn't have to be any special accommodations for LGBTQ employees. Is there a trend in workplaces happening now when folks are transitioning to actually provide those accommodations for folks?
Yeah, I've certainly worked with employers in the past where they've viewed an employee needing, time off for a medical procedure or something of that nature. They've viewed that as, we're gonna make that available on the same terms and conditions that we would for an employee who is asking for leave for another reason. Where I know some employers have had to give it some thought is about the bathroom issue. And so I think there's different ways to approach it. The default approach for resolving it that I've heard is to allow a transgender employee to use the restroom that corresponds with their gender identity. But it's not an issue that comes up every day. So I haven't seen necessarily a case where there's been a workplace dispute over that. You would need to be thoughtful about how you're going to respond to an employee who complains. But employers I've worked with have thought that, especially after this decision, they would probably want to put the onus on another employee to make an issue out of it rather than tell the transgender employee no on the front end. So that could be thought of as a kind of accommodation. The other area where employers, particularly those who want to present themselves as being friendly to LGBTQ employees and use that as kind of a way to attract and retain talent, is to make a point of when an employee discloses that they're transitioning, that the employer is supportive and essentially says, okay, well, we're gonna adjust our expectations on things like dress and grooming standards during the transition process. If you have any issues with the benefits carrier regarding anything that might be covered by insurance, let us know. So, a lot of this is actually about messaging. It's about signaling the employee that you're accepting of who they are. It doesn't necessarily mean that they're, get to deviate from your regular workplace policies in any meaningful way. But it's more about signaling that openness and that willingness to talk with them about their concerns.
Great. Questions from the audience at all? I've got another one here for you, Matt. There's kind of a viral post going around about a couple parents who have acknowledged their child is transsexual and is transitioning and has decided to use a new name. Is there anything specific in policies that companies need to put in there about a person who is transitioning, who has started using their new name, about any references to the dead name or the name that they're no longer using? Is there anything specifically we need to put into policies to address that?
Sure. I would often handle that on a case-by-case basis. I think if you were going to put something in a written policy, it would be the effect of, if an employee is transitioning and would like to change the name by which they are referred, they're encouraged to bring that to the attention of human resources. And really, I wouldn't get too much more into it than that in terms of what's in the employee handbook. One reason is because it's something where we don't want to necessarily want to make ourselves as the employer the arbiter of how everyone refers to the employee. If people occasionally make a mistake and call them by their previous name, unless it's being done maliciously or in a harassing way, we don't necessarily want to be involved in policing that. If the employee wants us to refer to them a certain way, I think it makes sense for us to comply with that request, and we can update their name on the company letterhead and et cetera, et cetera. And I think that would be the preferred course of action, is to abide by the employee's request. That said, though, we shouldn't be committing to enforcing the name change in a way where every time someone gets the name wrong, it becomes grounds for some type of internal discussion.
Thank you. Any questions from folks on the line? Well, I got another one for you, Matthew.
All right.
So, I'm kind of even though I'm not a member of the bar, I am kind of a legal geek. We joked yesterday how I burned through 3 highlighters going through the court case, going through the opinion. A 6-3 vote is unique. Isn't so unique when it comes to landmark cases like this, but for it to come from someone like Justice Gorsuch, kind of grabs your attention. Do you see anything in the 6-3 breakdown of how the justices voted that catches your eye?
Yeah, I thought that it was very interesting that Justice Gorsuch embraced the position that he did. This term, the more common scenario was you had sort of Chief Justice Roberts playing the swing vote on a couple of interesting cases and getting to some surprising outcomes. And a lot of people, myself included, chalk that up to Roberts as wanting to preserve kind of the court's institutional reputation as not being an overtly partisan organization. With Gorsuch joining the fray, this seems to be Gorsuch putting his stamp on what's called textualism. Somewhat ironically, he replaced Justice Scalia, who would have vigorously disagreed with the outcome of this case. And then he relied on a Justice Scalia opinion to help get to the outcome in the opinion that he was writing. So Justice Gorsuch is an avowed textualist or an originalist. And he used originalist reasoning to get to the outcome here. He concluded that we have to look just at the text of the law, and that's really all we should look at. We shouldn't look at whether members of Congress were interested in protecting LGBTQ people in the 1960s, because we can be fairly confident that they were not. We're not going to take that into account. He essentially says it's immaterial what Congress intended when they wrote the law. We're really just looking at the text of the law as written and what the plain meaning of that text is. And that was Justice Scalia's preferred method of reaching decisions. So Justice Gorsuch essentially has taken a Scalia method of deciding cases and joined a majority opinion to reach an outcome that Justice Scalia would have vigorously disagreed with. So it's a little bit of irony here. That Justice Scalia's prior opinions laid the foundation for an opinion that, written by his successor on the court, that he would have never, ever signed on to were he still on the bench.
Yeah, I think Justice Alito's dissent really kind of hammers on, okay, you say you're a textualist, but you're not really being a textualist here, and Scalia would probably be very angry that you're trying to call yourself a textualist here. So. Very, very interesting dissent for sure. That's where I lost 2 of my highlighters, by the way.
Yeah, the dissents in the aggregate are significantly longer than the actual majority opinion. The actual opinion by the 6 justices that sets out the law is I believe only about 30% or 40% of the combined length of the dissenting opinions. So very vigorous dissents, which Justice Scalia himself often wrote. Sort of loudly protesting this outcome, but the 6-3 is a commanding vote, and really almost indicates that perhaps Justice Gorsuch might end up be playing the role of Anthony Kennedy going forward on gay rights opinions, at least when it comes to being a textualist. That was Justice Kennedy's role for years as the swing vote on the court. And now that he's left the bench, it would seem that Justice Gorsuch is interested in perhaps filling that void.
Interesting. Yeah, I like you. I figured Roberts would be the swing here, but yeah, it'll be interesting to see how Gorsuch moves forward in cases that'll come before the court in the future. Because I know that in the opinion, he made a very big deal about saying that this was just about this situation. It doesn't deal with locker room issues. It doesn't deal with First Amendment issues. It doesn't deal with religion or anything like that. And we briefly talked yesterday about how that's just not going to happen, considering how many other federal statutes involve the definition of sex. So I thought that was also interesting in the opinion of the court.
Sure. Well, the judges, when they're issuing a decision, will often go to great lengths to talk about what they're not deciding in a bid to reassure anxious people about the scope of the decision. And most of those claims invariably prove not to be true. Typically, whenever the judges lay down an important principle of law, it almost inevitably impacts something else and will require additional cases to flesh out what it means. And that's emphatically going to happen here. You will see additional lawsuits challenging employer, insurance company, and other entities' policies under other laws that use sex as a legal term. So this is the first, and I would expect a series of cases that will rely on Bostock as their foundation. And that's just inevitable. But I think probably the more interesting fight is going to come over things like religious objections and use of facilities like bathrooms and locker rooms. And the lower courts are all over the place on those issues. So there's no way to know standing here today what the court would say in the future about a transgender employee's right to use a restroom that aligns with their gender identity versus their biological sex.
Excellent. We got time for about one more question. If there's any questions from the folks in the audience, Michelle or Sarah. Well then, let me just try to summarize here. So basically, we've got a landmark decision here. It does require employers to kind of, in some ways, use common sense in how they treat their employees to make sure that there's good communication, that there is some acknowledgement that there could be grievances in collective bargaining agreements that relate from this. That this is a good time to take a look at your employee policies when it comes to discrimination, when it comes to harassment. What am I missing there, Matt? I think that's a good snapshot, but I think I'm missing a couple things in that wrap up.
No, I mean, I think you're encapsulating it well. I think it's employers should take a fresh look at their existing policies and should make sure that they're updating their training, and they should really be thoughtful about ensuring that a lot of their neutral policies, if they have a transgender employee, that the employee really is able to stand on the same footing as their other employees with respect to those policies, whether that's medical leave of absence, whether it's access to benefits, or whether it's needing the employer to make some minor adjustments to policies during a transitioning process or things of that nature. And if you start from that foundation, I think that goes a long way towards mitigating or eliminating potential claims.
Excellent. We appreciate your time, Matthew, and sharing your knowledge with us. If folks have questions, want to follow up with anything specifically, they can reach you at Honigman, right? What's the best way to get a hold of you?
Oh yeah, sure. And I'm easily reachable by email. That's mradler@honigman.com. And my office line is 313-465-7716. Always happy to talk about this stuff. The end of the Supreme Court term is my favorite time of year.
Excellent. So we'll make sure to share that with our members. Again, ladies and gentlemen, thank you so much for joining us for today's webinar. Hope that you found it very useful. Remember, any information that you need, whether it's on COVID or whether it's on other issues impacting the workplace, you can get a hold of us at the Michigan Manufacturers Association. Our website is mimfg.org. You can also find our contact information on there if you need to get a hold of me or Mike or anybody else on the GA team, or if you got a membership question, how to get a hold of Delaney. We appreciate your continued support and wish you to have a wonderful Thursday and a great weekend. Thanks, everybody.
Thank you.